One hour.
If I might begin this afternoon with 2 points of detail. There's a question asked, I think, by my Lord Reid about the terminology of the legislation originally. Yes. And my Lord, the original legislation was, as my friend in Spain said, the Crime and Disorder Act 1998. The English provision, which did mention rehabilitation, was section 58(1). The Scottish provision, which introduced section 210A, was section 86. Ms. Spain and I have both looked at Hansard, and neither of us has actually found any explanation for why there is that difference. And I think, again, I'll be corrected by my other friend, the Advocate General, the English terminology has now in fact been brought into line with the Scots. That's the first point. The second point I should correct. I mentioned in looking at the public interest the fact that these proceedings were begun after Mr. Brown had commenced his constructs course. After. And what I should have made clear is, of course, there is a history to these proceedings which has been trying to track the developments in Strasbourg and in the Supreme Court. So at commencement, it was James that dominated. By the inner house, it was Cayenne and the Supreme Court. And of course, now it's Cayenne both in the Supreme Court and in Strasbourg. So it's an interesting journey for us all as the law develops. Coming, Lords, to bring what I was discussing with the court before lunch to a conclusion, that perhaps may assist to pick up one of the points that my Lord Reid was mentioning to me and asking me about before lunch. And again, I'm just looking at the moment at Strasbourg, and then I'll look at the domestic ancillary duty. The Lord has been asking me in particular about whether the ancillary duty could be regarded by Strasbourg as a 5-4 situation. Maybe I'm incorrect, that was my understanding, but I'll deal with it on that basis. But the fact of the matter is that in the cases in Strasbourg, James and following, they have been dealt with under 5.1a. Insofar as 5.4 is referred to, it's on the usual basis that having dealt with the matter under 5.1a, there's no need to deal with 5.4. So there is no 5.4 basis in Strasbourg. It's not to say that they've said it's irrelevant. More for my purposes, my Lord, what is important is looking at the ancillary duty, which is the sole issue before this court. And of course, what this court said in Cayenne was that the ancillary duty was based on neither 5.1a nor 5.4. That's why it's ancillary. So in the Supreme Court in Cayenne, if my Lords look to paragraphs 36 to 38, it's in the it's volume 3, tab 20, and the particular page is 1161.
1161, yep.
1161.
Thank you.
Perhaps the preceding page, 1160, is perhaps just worth mentioning, because I said about it from the context of ULA. Paragraph 35, what this court said was, for the reasons which we have given, we do not think it is possible to follow the reasoning of the fourth section of the European Court in James. It appears to us to be based on an overexpanded, inappropriate reading of the word unlawful in 5.1a. And that's perhaps a helpful point. Again, it's understood to be 5.1a. So it's the reasoning is not being followed. And we then see that the court proceeds to substitute its own reasoning. At paragraph 36, we consider the Supreme Court should now accept the fourth section's conclusion. And again, I apologise, I consistently refer to this as the Lord Diplock point, the difference between the ratio of the case, the conclusion and the reasoning. And it's particularly alive here because this court is distancing itself from the reasoning in Strasbourg. What is important is, and this is something that we will see, to use a phrase that's familiar in human rights analysis, a clear and constant line. This court acknowledges the limitation, I would say, to the decision. So we consider that the Supreme Court should now accept the fourth section's conclusion that the purpose of the sentence includes rehabilitation. In relation to prisoners subject to life and IPP sentences, in respect of whom shorter tariff periods have been set, we also consider that the Supreme Court can and should accept as implicit in the scheme of Article 5 the state is under a duty to provide an opportunity reasonable in all the circumstances for such a prisoner to rehabilitate himself, etc. It is my submission, in particular when one looks at the subsequent cases following James in Strasbourg, that one can accept that there is indeed that narrow perspective of those who are on indeterminate, that is life or IPP sentences. To pick the point that I was wishing to raise, and I apologise if I've misunderstood my Lord Reid, paragraph 37, the court specifically considers 5.4. Article 5.4 would be a more satisfactory home for any duty of the nature identified in the previous paragraph if its language covered it, which it does not. And then at 38, the duty to facilitate the progress of such prisoners towards release by appropriate courses and facilities cannot therefore be brought, in our opinion, within the express language of either 5.1a or 5.4. Hence why it's regarded as ancillary. So in looking at the ancillary duty, one sees it as, and I made this submission before lunch and I reaffirm that this is my position. It is this court's rationalisation of the conclusion in James to provide a remedy commensurate with and consistent with domestic legislation that says that prisoners should be detained for so long as they are a risk.
Strasbourg duty is clearly not one that's confined to indefinite sentence prisoners.
That is correct. Well, so the 5.1a is not. The application of it to rehabilitation is the point I was trying to make.
Well, that's not confined to life prisoners.
No.
Indefinite.
As my Lord has noted in my written case, what I have noted, in particular by reference to the Grand Chamber case of Murray, is there's an increasing reference to rehabilitation. But where it has been translated from, in a sense, an aspirational objective into a positive duty that may give rise to a breach of 5.1a, it is in strictly limited circumstances, and that's all. So I'm drawing the difference, my Lord, between a developing aspirational objective. This is why I refer to ULA, of what is yet being converted into a positive obligation. And that perhaps takes me directly.
Well, can I just ask you, before we leave that, I mean, if for example, you have the prisoner we discussed before the short adjournment, who might be the one who's been given a 20-year sentence,
yes,
and he might be released after 20 years, or he might be released after 10 years, depending on the parole board's assessment of risk, an assessment which might depend on his having undergone the various courses that it would recommend. Now, the courts, the Strasbourg court would regard that person as falling within the scope of Article 5.1a in relation to provision of the opportunity to rehabilitate himself. Would you not?
The answer to that, Lord, is for that individual, I would submit that it's not certain. And the reason why it's not certain is when I turn to the Kayam case, because it's looking for something that's exceptional, and it is caught up in the point that was debated, and if I can simply say the debate between Milady and my Lord in the Chair in Whiston about the reach of 5-4. Some of the Strasbourg case law has some artificial distinctions that are derived from the architecture of the Convention. In a situation such as my 20-year individual, it's my respectful submission that, if I may respectfully say so, my Lord in the Chair is correct in Whiston that the analysis would be that Strasbourg would say that the review required by 5-4 is built into the original sentence, and therefore 5-4 is not breached. Whether the conclusion would be that for that individual, his sentence has become arbitrary because of an absence of rehabilitation is, if I may put it this way, I intend to do no more than that, is the ULA question. In other words, what would they decide? If your Lordship is of the view that they would certainly decide in favour of that individual, then the ULA question is answered. If it's left in doubt, then the development is for Strasbourg. And perhaps, Lord, I mentioned that the 20-year individual just simply to look at perhaps this no more, to say, as I started, and it's the reason why I don't wish to pick up the discussion between my Lord in the Chair and my Lady about the distinction between determinate and indeterminate sentences for 5-4. It doesn't arise for us in this case. The reason I mentioned the 20-year individual is just simply to show how artificial it is to approach the issue in this case with such artificial distinctions in mind. They ought not to be determinative. It is a broader question. And that's what takes me to Kayam in the Strasbourg court.
Well, if I dispense with artificiality, then the reality of a 20-year sentence is, as the judge explains to the prisoner, but it's in reality 10 years minimum in custody, and what happens after that depends on an assessment of risk.
That is correct. That is correct. And if I may, because this is a multifaceted point, the point that I mentioned to my Lords by reference to the English case of Whiston and the English statutory provision is that where my learned friend Miss Bain says that risk is in a unique category for extended sentence prisoners, I submit that it is not. That risk is at the heart of the parole system applied to all prisoners. It may have a more or less statutory foundation in one case as opposed to another, but the distinction my learned friend seeks to present is not correct. And perhaps, and the 20-year example I use, which was simply to illustrate that point, is the sort of exceptional case that one would look at, in particular in a common law perspective, quite closely. The point I wish to make, and it's a fundamental point when we come to Kayam in Strasbourg, that is what is thought to be a rule that will produce a result in a rare case is, on my learned friend's reasoning, in fact going to apply to every case and ordinary circumstances. And it's that which, at bottom, I say, is where this process of following the reasoning to its logical conclusion meets the Lord Diplock point. Stop. Is that really going well beyond the circumstances that led to that conclusion? And if I may, with that in mind, look at Kayam in Strasbourg. It's in volume 5, I believe. Volume 5, tab 45.
Yes.
And where I wish to pick up is at paragraph 70, which is, perhaps I should begin at paragraph 67, page 1758.
Yep. Yes.
Lords, what I'm going to use this for a variety of purposes. When we look at ULA, Your Lordships will be familiar with the approach that one looks for a clear and constant line in jurisprudence. In paragraph 40 of my note of argument, I quote what has become the now cut and paste explanation in Strasbourg of the James decision. I quote 4 authorities which have this same passage. There is a 5th, a case called Black against the United Kingdom that's mentioned in Khayyam in the Supreme Court. I mention this because it does stress the indeterminate nature of the sentence. So at paragraph 67, the court says, in James, the court explained that in cases concerning indeterminate sentences of imprisonment for the protection of the public, a real opportunity for rehabilitation was a necessary element of any part of the detention which was to be justified solely by reference to public protection. It follows that, strictly speaking, 5.1a does not require a real opportunity for rehabilitation during the tariff period itself, since this represents the punishment part of the sentence. I want to also come back to that second sentence in looking at the practicalities. Sorry,
But the Strasbourg Court's approach is not confined to prisoners serving indefinite sentences. If you go back to MS 128, you cite what it said in Murray. Personally, in Murray's in the what I thought was the main line on this topic about rehabilitation, and you'll see the quotation from Murray in your paragraph 33 and paragraph 103. The court's case law thus presupposes that convicted persons, including life prisoners, should be allowed to rehabilitate themselves.
But that's correct.
And it's not a special, life sentences aren't in some sort of exceptional category.
Well, if I may, my Lord, one of the points of looking at Murray is that the passages in Murray look beyond the immediate James-type obligation of providing courses. So the examples given in that passage in Murray include a Russian case, which was Article 8 and prison visits. They also include the Italian case, Mastro Matteo, which is not far removed from the context of Dorset Yacht. It's an individual on temporary leave who commits a horrendous murder. So they're looking at rehabilitation in a very broad sense. What I do, though, stress, my Lord, is even when one looks closely at the passages in Murray, as my Lord will no doubt do, it does not translate it into specific positive obligations. The specific positive obligations are of a narrower type. And perhaps, as I said to my Lords earlier, I'm drawing this distinction between the duty on the one hand and the threshold of breach, because I'm trying to avoid a situation in which there is endless litigation. Plainly, if the threshold is set very high, then the fact that the duty is more extensive produces the same result as a narrower duty operated at a lower threshold. One can produce the same net result. And it's the net result we will see in Khayyam in the Strasbourg Court that's intended to be narrow. I'm submitting to your Lordships that one approach of producing that same narrow net result is to take a cautious, narrower view of the scope of the duty, because it is consistently referred to in the subsequent Strasbourg case law as one applying to indeterminate prisoners. And part of the logic is, if one looks at James, it wasn't just said in James, the object is rehabilitation. They looked at the fact that it was an indeterminate sentence. They looked at the fact that for many of the individuals under an IPP sentence, the court was given no discretion. The fact that there had been a prior conviction meant that there was an assumption of risk consistent with imposing an IPP sentence. So there were features specific to an IPP sentence that led to James. And it's that combination of special feature, whether one looks at it as the nature of the duty or the breach, that is particularly spelt out by the Strasbourg Court in Cayenne. So it's Volume 5, tab 45, and I'm looking at paragraph 70, which is at page 1759.
Right.
Paragraph 70. It is clear from the court's case law in this area that cases in which it is prepared to find that a period of post-tariff detention has failed to comply with the requirements of Article 5.1a on account of a delay in access to rehabilitative courses will be rare. Stop there, and there are 2 points. First of all, I'd stressed rare as being consistent with Lord Reid's analysis in Sternum of the exceptional circumstance. But the challenging point in my respectful submission is, if we are looking at rehabilitation, as this court says, the duty must predate the tariff date. In Scotland for lifers, it's a 4-year lead-in period, because only if one starts 4 years back from the first meeting with the parole board will somebody be in circumstances where he is ready to be assessed properly. Strasbourg is looking at the post-tariff period. It's clear from the court's case law in this area that cases in which it is prepared to find that a period of post-tariff detention has failed to comply with the requirements of 5.1a on account of a delay to access rehabilitative courses will be rare. So it is that, my Lord, and I make no apology for simply having said that in looking at the various strands of the law, one has to analyse each separately. The court is not saying in a 5.1a situation in these cases that, say, 2 years prior to the meeting with the parole board, there is a breach of 5.1a because there's been no rehabilitation. It's looking to detention post-tariff because prior to the expiry of the tariff period, the detention is lawful. That comes back to Whiston. So it's rare, and the court proceeds. In particular, it's not for this court to second-guess the decisions of the qualified national authorities as regards the appropriate sentence plan. It refers to Dillon, Alexander. Alexander I'll come back to. Neither is it the court's role to impose a particular timetable on authorities. Any delays encountered in the provision of specific courses must be assessed in the context of the gravity of the offence, the amount of offending behaviour work therefore required, and against the backdrop of the range of rehabilitative courses already accessed by the applicant. That's Alexander. Now, that's also in this court's test of breach in Cayenne. And it's simply, as I've said, in relation to Mr. Massey, there was a difference of opinion as to whether there was a breach in his case or not. But I'll come back. That's really the point that encapsulates the test of breach. Look at the assessment as a whole. Look at what he's done before tariff as well as post. And then the court says this to back up what is said about the breach being rare. It says, in finding a violation in the case of James, the court drew attention to the fact that substantial periods of time passed in respect of each applicant before they even began to make any progress in their sentences. They had therefore not been afforded reasonable opportunities to undertake courses aimed at helping them address their offending behaviour. The first and last sentences really read together. That's stressing the rarity of this. And as I've said, I'm seeking to persuade your lordships to take a narrow view, because otherwise the duty would extend to every category of prisoner. in any situation of delay. There would then be pass on to the second analysis, is there a breach? And it's my submission that what is intended as a very practical ruling in James to deal with an extraordinary and thankfully rare situation should not be taken any further. As the court recognised in Khayyam, this court recognised in Khayyam, James itself was not something that had been forewarned in advance. They'd not been leading up to it. Indeed, I mention some of the German cases in my written case that are discussed in Khayyam. German cases of preventive detention. And in those cases, no breach of Article 5 was found, even though in one of them, the individual said, I have not been given access to courses. The court in that German case did not even discuss the complaint of an access to courses. So James is a development. I'm not asking, as I've said, that Khayyam be, in this court, be thought to be wrongly decided. I am asking that it be recognised as a rare example and there to protect against a rather extraordinary wrong that was being committed by the executive in that situation. As I've said to the court on every occasion post-James, in which cases of this sort have gone back to Strasbourg, no breach of 51A has been found, no violation of the Convention right has been found. And accordingly, what I submit to the court is that we now are in that situation where this court, having intended in terms of ULA, respectfully to follow and give effect to the conclusion, is now being presented with an argument that it should go beyond the conclusion and in fact give free rein to the reasoning in James, the reasoning in Murray, which this court has itself said we are not going to apply the reasoning. We will respect the conclusion but not the reasoning. It is my submission that the proper approach is to recognise that the difficulty that drove James was of a narrow nature. And if I may, I picked up one of the points that I said I would come back to in relation to the formulation in Khayyam, in Strasbourg. It's clear that from the court's case law in this area, that cases in which it's prepared to find that a period of post-tariff detention has failed to comply with the requirements on account of delay in access will be rare. There is, applied in our circumstances, in my respectful submission, a somewhat ironic sort of twist. In the case of a life prisoner, an IPP, or in Scotland, an order of lifelong restriction, I accept what Lord Reid is suggesting. The duty is one that predates the first encounter with the parole board. It is therefore a necessary precondition of the individual being released. And in Dorset Yacht terms, it's also, on the flip side of the coin, necessary to protect the public. One should not release a prisoner if he's going to pose a risk to the public. That is why this court recognised that the ancillary duty will become operative before the date that Strasbourg is speaking of. It's operative before, because in the case of a lifer, the 4-year lead-in. But in those cases, the duty produces the practical result that we're seeking. The prisoner has improved prospects of release because he has undergone courses. The protection of the public is maximised because the prisoner has it undertaking the courses. The argument for the appellant is, because of the peculiar nature of an extended sentence, this duty first applies on recall. So in September 2010, the example, which is not really apposite, is to say that that's to bolt or lock the stable door after the horse has bolted. Because, of course, what has happened is the individual has been released. As in Mr. Brown's case, he has offended. He's now being recalled. And it is said for the first time, there is now a duty to rehabilitate him so that he can have the prospect of being released again, and to protect the public should he re-offend. In my respectful submission, that just logically doesn't follow, because the harm has been done. In Mr. Brown's case, thankfully, the harm was at the lower end. It was theft of a car. But it's not difficult to see that in the types of individual who are the subject of extended sentences, sexual offences and more serious violence, that the harm that could be inflicted could be grave. Now, the prospect of saying that there's a duty to rehabilitate that individual should he commit a second serious offence and be recalled, but no duty to rehabilitate him prior to first release, defies logic. And of course, I'm not here to justify the rationality. That's why, again, with apologies, I refer to Lord Diplock. People face crime. Not just, they can face crime at the hands of a first offender or someone who hasn't been caught. They can face crime at the hands of someone who's released but not properly rehabilitated. Much more to the point, as in the example of someone like Mr. Brown, someone who is judged to be a risk. The public faces the risk because it is mandatory to release those individuals at his time after 2/3 of the sentence. That is what Parliament has decreed. So that is the law, but in my respectful submission, to recognise an ancillary duty that only applies after recall is not practical. It does not fit the purpose. We have carried out some research to find out the numbers, because my learned friend has said those who suffer extended sentences can be detained for up to 10 years as an extension period. I can't give the court complete numbers, but of those currently held in the custodial terms, I can't give the numbers for recalled prisoners. There's about 580 people in Scotland in the custodial term of an extended sentence. 75% of those have an extension period of 4 years or less. Mr. Brown's was 3 years. 40% of prisoners have that type of sentence. Now, of course, recall is a completely random event. It conditional on when the breach of licence condition occurs and comes to the attention of the authorities. The lead-in period for extended prisoners on the current policy is about 2 years. So one is looking to put them on track for the parole board hearing 2 years before they will encounter the parole board. 2 years. For 40% of individuals, frankly, for this duty to apply to them, they better re-offend jolly quickly, because they'll otherwise be within the 2-year period and not much can be done. And of course, when they're recalled, what happens to them very much depends on their reason for recall. So an individual recalled for re-offending is initially held in effect on remand, pending the outcome of the prosecution. Now, in Mr. Brown's case, that was very quick and resulted only in a 40-day sentence. But one's beginning to see that the practicalities of this, of actually achieving a great deal for the majority of those who are recalled in the extension period, are actually quite limited. Now, that's not to, again, get away from the point that I've accepted from the Lord Reid, that the general object is to rehabilitate. I accept that. But the practicalities of this duty, achieving an object other than, and I make no apology for this, creating a conveyor belt for claims, the practicalities of this duty, creating a practical result, are very limited indeed. That enables me then to turn, I trust very briefly, because I've essentially covered it, the question of breach. So from duty to breach. It is my respectful submission that, and this is no disrespect to the inner house, because matters have become clearer as a result of CAIAM in Strasbourg, stressing the rarity of breach and, again, reaffirming the need to look at the detention period as a whole. What is wrong in this case is that Mr. Brown looks at a period in isolation. He should not do so. What one requires to look at is the totality of his time in custody. And if one looks at that, and it may be better simply to look at it in the chronology attached to the statement of facts and issues in this case. Because that in the core volume is page 86. Of course, one is entitled, in terms of CAIAM, to look, as it said, pre-tariff, post-tariff. He was sentenced on the 5th of January 2006, his sentence backdated to the 3rd of August 2005. He underwent anger management in December 2006. In August 2007, the Constructs programme, the very programme that's given rise to this case, August 2007. September 2009, alcohol awareness, first steps drug awareness. If I go over the page to page 87, he is recalled on the 30th of September, sentenced on the 21st of October to 40 days. Then 12th of November, the case conference, the 8th of December 2010. These are the two dates where the duty is said to commence, either November or December 2010. While he's waiting, at page 88, in September 2011, he completes an alcohol awareness course again. Highly relevant because his initial offence and the car theft were influenced by alcohol. Then in February 2012, he undergoes what is called a generic programme assessment, and perhaps there are some words that need to be explained. At one stage, individuals were separately assessed for each specific programme that was on offer in any particular prison. That was thought to lead to a duplication of effort and indeed the potential for missed constructive management of a prisoner. So now there is a generic programme assessment, in other words, a single assessment carried out by reference to the range of programmes that are available to decide what is appropriate. The very fact that he is being monitored and assessed is something that, as we will see in the later cases, is itself picked up. So he is someone who is having some courses provided, albeit, and we then come down to the bottom, it's not until January 2013 that the constructs programme is offered. So there is a gap of just over 2 years. But it's not a gap that is unpopulated. He is being given alcohol awareness and the generic programme assessment. I'll not take up the court's time by looking on, because we see, looking on, even with the benefit of these courses, his progress is undistinguished. And indeed, he never progresses to a point of release, and not because of the absence of programmes, but simply because of his behaviour while in prison. And I needn't really say very much. It's detailed if one follows through the references. In trying to show the court how this translates, perhaps the best example is simply to show the court the case that's mentioned in my written case, and that is the case of Alexander.
Yep.
And there are 5 of these, so that one could look at any one of 5. Alexander is in volume 4, tab 35. And if one looks at page 1498, paragraph 46, one will see the analysis. And what is important for this is Alexander's a sex offender. It's, as in some of the cases in Khayyam, it's the failure to provide him with the extended sex offender treatment programme. There's a 4-year delay. 2 years pre-tariff, 2 years post-tariff. What the court says at paragraph 46 is this: it is true that following the expiry of his tariff, and with the exception of some group work, the applicant does not appear to have participated in any rehabilitative programmes until August 2014. That's the 4-year gap, despite the extended sex offender treatment programme having been recommended in April 2010. So there's the 4-year gap. However, it is clear that throughout the period during which the applicant was awaiting a place on the programme, he was being monitored and assessed as appropriate, with a view to ensuring his progress through the prison system and eventual release. The reasonableness of the delay in accessing the programme must further be viewed in the context of the gravity of his offence, which necessitated extensive offending behaviour work and the imposition of a tariff of almost 5 years. It must also be considered against the backdrop of the wide range of rehabilitative courses which the applicant had already accessed before the expiry of his tariff, and which allowed him to present evidence to the parole board of a reduction in the level of risk that he posed. Finally, insofar as the applicant appeared to complain about further rehabilitative work now required, it's not for this court to second guess. And then there's paragraph 48. In the present case, it can be seen that, unlike in the case of James Wilson Lee, prompt steps were taken to begin the applicant's progression through the prison system. He was given access to a wide range of rehabilitative courses which enabled him to present evidence of risk reduction. In these circumstances, the court is satisfied that a real opportunity for rehabilitation was provided to the applicant, and there was no unreasonable delay in providing him access to courses. There has accordingly been no violation of Article 5.1 of the Convention. In my respectful submission, on all fours, and indeed more extreme than Mr. Brown's case, and the other cases which are cited in my paragraph 40, including the one that's omitted, Brown, are cases of this sort. Delays beyond this have not resulted in any breach. So in summary, it is my submission that the court should look at duty narrowly. I accept what my Lord Reid has put to me, and indeed I brought it forward myself, one can find in the cases, in particular in repeated Grand Chamber cases, a growing reference to emphasis on rehabilitation, but as I submit, not yet translated into a Strasbourg breach, potentially of 5.1a. So 5.1a and its domestic analogue, the ancillary duty, should be narrowly confined to the circumstances recognised in James and Cayenne. Breach, in my respectful submission, should equally be a high threshold. As I have said to my lords and my lady, I do not discern, even though there's the difference in outcome between Massey in this court and in Strasbourg, I do not discern a difference in test. Why would there be? Because this court was following James. It's simply a difference of different decision makers, a view of the facts. But perhaps one can say this, that the outcome of Massey does indeed stress that mere delay is not sufficient. One is looking for something rarer or, in Stirling terms, more exceptional. That then takes me only to this in relation to quantum. And I will leave this to my learned friend, the Advocate General, both because it's his point. I have tried to avoid the narrow distinction between determinate and indeterminate, the precise nature of an extended sentence. Plainly, on my learned friend's submission, this court is being asked to go so far as to hold that Sim is wrongly decided, that Sim drew the line at the wrong spot. £500 would be the appropriate quantum if the court went that far. And it's interesting, if I may, and again I don't really wish to open this up, but for my learned friend to go fully that far, it might even result in Milady Hale being asked to go one step back and even hold that discretionary parole is a point of distinction. I don't wish to go there, but we don't need to.
You don't wish to go there, but you just have.
And I will now retreat. One tests the water sometimes. But more to the point, the distinction is my learned friend, to justify £500, must persuade this court that Sim drew the line in the wrong place. It's my submission that there is no support for that proposition. And accordingly, in agreement with learned friend, the Advocate General, if the line has to be drawn, and I say not, at the point where the extension period begins, because that is August 2012, just a little short of 6 months, a lesser sum should be awarded. And I don't wish to engage on whether it's £300, which was the Stirling figure, or 250 or something less. That's the issue of principle. But my primary position, the reason why I did not go into quantum, is that in my respectful submission, this appeal fails because it has not been demonstrated that it is in the public interest that this court extend the ruling in Cayenne, the ancillary duty, extend it into territory where Strasbourg would find no breach of the corresponding provisions of the Convention 5.1a and 4. It's simply a case where the reasoning is being extended beyond the proper scope of the decision. And I invite the court to restrict itself to the decision. And on that basis, I invite the court to refuse the appeal. Unless I can assist my lords and my lady, those are my submissions.
Can I just ask one question about the facts?
Yes, my lord.
You were drawing our attention to passages in Alexander and citation from Dillon to the effect that it's not the job of the Strasbourg court to second-guess decisions taken by the prison authorities about the management of individual prisoners. And that's obviously right. We have On the other hand, in the present case, we have the parole board decisions, and it looks from them as though broadly similar management plans were presented in 2010, 2011 and 2012, and little progress was made, partly, the parole board says, because the prisoner had been unable to access the programme work. But it also goes on to say that they also noted that he'd incurred quite a number of misconduct reports which would have been taken into account in considering a decision about his suitability to progress.
Yes.
And I simply wondered whether we had any more documentation in the rather voluminous papers we have dealing with that factual question.
The answer to that is that there are two answers to that, my Lord. First of all, the Lord Ordinary in this case was presented with a reasons challenge, and the answer was that she concluded that the misconduct was itself a secondary reason for withholding parole. So there's some discussion by the Lord Ordinary. The answer to my Lord's point, and I now kick myself because I noticed this yesterday, if one goes through the various parole boards' decisions, there are references to the number of misconduct
yes, that's
charges.
what I've been doing.
And there's also a sheet. The reason why I'm kicking myself, look, there is somewhere in that bundle, there is a sheet that has a set of misconduct charges. I will, as I sit and listen, I will find it. Lord, so far as the actual decisions, just a moment. 440, actually, thanks.
Yes, I'm raising the matter because it rather looks as though it's not so much a case of the management plans being questioned, but rather of being reasons to do with his conduct, as well as reasons to do with the availability of courses,
yes,
as to why he didn't progress.
With respect, my Lord, that is correct. And if Your Lordship will allow me just a moment. There are two ways of going about this, my Lord.
It's 314 seems to have lots of misconduct rules.
Well, we can perhaps be given details of this at a later stage when you've identified the documents.
If Ranifed isn't able to do so, I will give my Lord a note.
Thank you.
Because one can take it from the parole board decisions that there is a summary of the number of misconduct charges from time to time. I just haven't done that.
MS 314 and following seems to have a large number of misconduct charges.
314.
MS 314, is that what you had in mind?
Thank you very much. That stops me kicking myself. That is the sheet, and there are a number of sheets.
Yeah.
That I'm very grateful to my Lord.
Thank you.
So
Yes, that is.
that's all you want to draw Lord Reid, our attention to as a result of Lord Reid's question. There's no
Yes,
other
Lord.
document. Thanks to Lord Hodge, we have that. Thank you.
Perhaps I'm being corrected by Mr. Ross, who argued the case at first instance. Maybe the misconduct is not a secondary reason, it is one of the reasons.
Yes.
Where they rank is for my Lord to read the decisions. But yes, there was the misconduct dimension in addition to the absence of rehabilitation. I'm grateful to my Lord.
Thank you, Mr. Ross.
Shift this.
Mr. Ross? Thank you very much. Advocate General, do take your time sorting out the lecterns and the microphones.
My Lords, my Lady, Could I begin by inviting the court to refuse the appeal? In doing so, I adopt the written case already submitted on behalf of the second respondent, and also adopt on all matters, apart from the measure of quantification of damages, the submissions made by my learned friend, Mr. Moynihan, on behalf of the first respondents. And it may be that I will not have a great deal to add to the submissions already made, but I would wish to just elaborate upon a number of issues concerning the basis of the ancillary duty with which we're concerned, and how it stands in the context of the Strasbourg jurisprudence with regard to Article 5, and in particular Article 5.1. At the core of the appellant's case is the submission that when determining whether the ancillary duty recognised in Kime applies to a particular prisoner, the court needs to examine the purpose of the sentence. And that's set out in the Statement of Facts and Issues, paragraph 4 at MS 82. There's then the alternative argument that the duty applied to the appellant because of the stage of his sentence. And in that context, we've had the elaboration that it was upon his return to custody that this duty was somehow triggered. Now, of course, as my learned friend Mr. Moynihan has noted, rehabilitation is always an aspiration in the context of penal penalties or penal life. It's an aspiration, or as he termed it, an objective. But that doesn't mean that one automatically identifies the existence of the relevant ancillary duty. The appellant effectively begins in the wrong place, and as a consequence has led to the wrong conclusion. Looking to the ancillary duty itself, and let me cut to the point immediately, and indeed to the corollary duty recognised by the European Court of Human Rights in Strasbourg, it addresses a very distinct issue, that of what was termed by Lord Judge as penal oblivion or perpetual limbo for those who were made the subject of IPP sentences. For them, there was no identifiable endpoint. There was a tariff, but of course their sentence could continue beyond that tariff. And in circumstances where they were condemned to such penal oblivion, there was the very real perception that their detention could become arbitrary for the purposes of Article 5.1a of the Convention. I'll come on to the point of what is arbitrariness in this context in a moment. And so it was that very particular issue in my submission that led to the development of the jurisprudence in this area, and in particular led the Supreme Court to determine that although it could not accept the analysis of the Strasbourg Court by reference to 5.1a and its consequences, it should nevertheless recognise the result by the implication of the ancillary duty we've seen referred to in Article 5. And I wonder if I could just begin by referring to the observations of the Strasbourg Court in the case of James. It's paragraph 209, which is MS 1735. James itself is tab 44 in the bundle of authorities.
1735.
1735.
Yep. Yes.
Now, I hope I'm not taking this in any way out of context, but I don't propose to take your lordship through the case law at length at this time. Your lordships will be familiar with it and have been taken to it already. But at 209, the court observed this. The court is therefore satisfied that in cases concerning indeterminate sentences of imprisonment for the protection of the public, a real opportunity for rehabilitation is a necessary element of any part of the detention which is to be justified solely by reference to public protection. In the case of the IPP sentence, it is in any event clear that the legislation was premised on the understanding that rehabilitative treatment would be made available to those prisoners on whom an IPP sentence was imposed, even if this was not an express objective of the legislation itself. Indeed, this premise formed the basis upon which a breach of the Secretary of State's public law duty was found and confirmed, of course, by the court. The court accordingly agrees with the applicants that one of the purposes of their detention was their rehabilitation. Now, in my respectful submission, that has to be read in the context of a situation in which, without there being such a duty and simply an aspiration, such prisoners would be condemned effectively to penal limbo, with the consequence that their detention or continued detention, particularly post-tariff, could be construed as arbitrary. But of course, the duty, the ancillary duty that this court recognised is slightly removed from the analysis of the Strasbourg court. But I stress again, the result is the same. In each case, one has to end up in a position where you can say there is or is not a breach of convention rights. And looking to the way in which the ancillary duty operates, if I can refer your lordships to Kayam itself, at paragraph 48, I think MS 1165, in the Supreme Court, paragraph 48, 3 lines, 4 lines down, there's a reference to whether there was a failure to meet the requirements set out in James, and thus a breach of the ancillary obligation contained in Article 5. And the court goes on to observe, this ancillary obligation clearly exists throughout the prisoner's detention and is separate from any obligation to release, whether under domestic law or the Convention. It is geared towards the prisoner having a reasonable opportunity to establish that he is safe to release at or within a reasonable time after the expiry of the tariff period. A failure before tariff expiry may thus constitute a breach if it remains uncorrected, so that he is deprived of such reasonable opportunity which he ought to have had. Such a breach may sound in modest damages if the impact on the prisoner warranted. It cannot of itself give rise to a duty to release, for whilst the prisoner remains unsafe to the public, there is ample justification under Article 5.1a for his continued detention. The question is accordingly this: was Hannay afforded a reasonable opportunity to reform himself, and crucially in his case to demonstrate that he no longer presented an unacceptable risk to the public? So the ancillary duty is one which actually exists throughout the period of the IPP sentence, and indeed may be breached even before the prisoner meets the tariff point of the relevant sentence. And it is because otherwise his detention will be effectively indeterminate and consequently arbitrary. And it would be wrong, therefore, to suggest that the ancillary duty is in any sense coextensive with the duties arising under Article 5.4 of the Convention, which is a point that crept repeatedly into the appellant's submissions. that if the duty under 5.4 had emerged, then the ancillary duty had emerged with it. That is simply not the case. Whether you accept the majority view in Whiston or the view of Lady Hale, is nothing to the point in that context. Whether you say Sim is right or wrong is nothing to the point in that context. The point is that this ancillary duty, as properly understood, applies throughout the period of the IPP sentence in order that the relevant prisoner may prepare for tariff expiry. And it continues thereafter, of course. And just on that point, if I can refer to the opinion of the Supreme Court in Kayam at paragraph 38, which is at MS 1161.
Yep.
The duty to facilitate the progress of such prisoners towards release by appropriate courses and facilities cannot therefore be brought, in our opinion, within the express language of either Article 5.1a or Article 5.4. But it is on any view closely analogous at an earlier stage to the duty involved under Article 5.4, and it is far more satisfactory to treat it as an analogous duty arising by implication at an earlier stage than that covered by Article 5.4, rather than to treat Article 5.1a as incorporating it. We consider that a duty to facilitate release can and should therefore be implied as an ancillary duty, a duty not affecting the lawfulness of the detention, but sounding in damages if breached. Such a duty can be readily implied as part of the overall scheme of Article 5. Again, the ancillary duty is not something that arises out of Article 5.4 and is not coextensive with Article 5.4, albeit it may be analogous in certain ways. Now, I pause there just to make this observation, my lords. While the Strasbourg Court approached the matter by reference to Article 5.1a, and the Supreme Court approached the matter by reference to this ancillary duty, the result must surely be the same, that either there is or there is not a breach of convention rights. Because quite apart from anything else, how would you otherwise trigger Article 8 of the Convention? And, I'm sorry, Section 8 of the Act. I said Article 8 of the Convention. I do apologise. How would you otherwise trigger Section 8 of the Human Rights Act? Now, looking to the approach taken by Strasbourg, you have a situation in which they said if you have an IPP prisoner and you have no provision by which he can meet the requirements for his release post-tariff, then his detention is potentially arbitrary for the purposes of 5.1a. If you contrast that with the position that the appellant takes with regard to the ancillary duty, surely one is entitled to ask, in what sense could Mr. Brown's detention be regarded as arbitrary when he is serving an extended period of imprisonment as defined? He knows that he will be entitled to release at a specific point in the course of the custodial element of his sentence. He knows that he may be released at the expiry of the custodial period of his sentence, less the provision under Section 1.2 of the Act for him to be released on licence. Even if he breaches his licence, which is what brings him back into custody, remember, he knows that ultimately he will be released at the end of his extended period of sentence. There is in no proper sense an arbitrary detention of the appellant serving an extended sentence, any more than there is an arbitrary element to the detention of a prisoner serving a determinative sentence, which is subject to parole at the halfway point. So, it does respectfully appear to me, and I seek to submit, that clearly, while there is scope for an ancillary duty of rehabilitation, it is to be clearly, and the learned friend Mr. Moynihan suggested, narrowly construed by reference to the particular issue or problem that it has to address, namely the risk of penal oblivion in the case of the IPP prisoner, with the result that his detention or continued detention would be regarded as arbitrary. I mentioned that I would come back to what we mean in that context by arbitrary. It is touched upon by the Supreme Court in Kayam at paragraph 26, MS 1157.
Yeah.
Paragraph 26,
Yep.
Arbitrariness,
Yep.
which might at an international level affect lawfulness under Article 5.1, is relatively confined. The main examples which the European Court gave of situations in which detention might, although lawful under domestic law, be unlawful under the Convention were A, detention following on the unlawful kidnapping or luring within the domestic jurisdiction of a person, or it goes on B, the deprivation of liberty must generally be for one of the purposes permitted by Article 5.1 and must, in the case of sentence, retain a sufficient causal connection with the original conviction. So I don't read it out in full, but I simply observe that when we are talking about arbitrariness in this context, it is a term which is relatively confined for these purposes. Well, Lords, if we look at the alternative argument advanced by the appellant, then I simply observe that it is not at all clear where or when this ancillary duty is going to arise. Is it, as the Court has already determined, going to arise throughout the period of the extended sentence? And if so, why? And if so, why distinguish it from a determinative sentence? Is it going to arise at the end of the custodial period of the sentence, for the period of the extension? And if so, why? Certainly on the basis of Whiston, no duty arises pursuant to Article 5.4 prior to the termination or term of the custodial period of sentence. So why should this ancillary duty somehow arise in these circumstances? There is simply no structure to the proposition that the duty so narrowly defined both by Strasbourg and the Supreme Court should be extended in any way for a distinct and separate purpose to that which it was intended to apply to, namely the risk inherent in IPP sentencing if no duty of rehabilitation was to be inferred.
What was special about IPP sentences was that the detention, the way it was put in James was to say that the detention was justified solely by considerations of risk to the public.
Indeed.
The argument might run if there are other periods of detention which have the same characteristic, then the same principle would apply.
But with respect, what is materially different is that in the case of the IPP sentence, the sentence is indeterminate, and that is why the duty of rehabilitation has to be implied in that case. That does not apply to the case of the extended period of an extended sentence. The prisoner knows that at the expiry of, in this instance, I believe 3 years, he will be released. There is a terminus so far as his detention is concerned. That doesn't exist in the case of the IPP, which is why both Strasbourg and the Supreme Court focus repeatedly throughout both James and Khan upon the nature of the sentence which has been imposed, the indeterminate nature of that sentence.
I
Or the
think
risk
in
is, as it
James,
is.
they're talking, the rehabilitation procedures that they're anticipating in James are different from the ones which are available to ordinary long-term prisoners. That is to say that the nature of the rehabilitation they're envisaging is not the same as will exist for, I think that's paragraph.
It may have to go further, for example, in the context of violent sexual offenders, in order to ensure that they are safe upon release. I mean, the reality is that rehabilitation is an aspiration for all who are subject to imprisonment. But we know that it doesn't always work. In the case of someone subject to a determinative sentence or an extended sentence, they will in any event be released from prison at a particular point in time. In the case of the IPP prisoner, he will simply not be released. And the onus is, of course, upon him to satisfy the parole board that, in fact, he no longer poses a risk if he is released.
The way they put it at paragraph 194 is to say that...
I'm sorry, my Lord, paragraph 114.
The way the Strasbourg Court put it in paragraph 194 of James was to say that for a deprivation of liberty not to be arbitrary, so there's 5.1a, there must be some relationship between the ground of permitted deprivation of liberty relied on and the conditions of detention. So if the ground relied on is danger to the public, then for that not to be arbitrary, the conditions of detention would have to include something designed to address danger to the public.
From the outset of the sentence. My Lords, can I come on just to touch upon some brief submissions on the facts? I appreciate my learning from Mr. Moynihan has already been there, but it's common ground that the appellant did undertake rehabilitative coursework prior to his release. And that's found in the Statement of Facts and Issues at paragraph 7, MS 83. And there's a chronology at MS 86 setting out the program that he undertook prior to his release.
Yeah, we looked at that. Yeah.
And clearly, these were not courses preparing him for tariff expiry, because there was no tariff expiry, but they were carried through on the basis that one of the objectives of his sentence was rehabilitation. The point was made that the term rehabilitation had been taken out of some of the statutory provisions, but there is an overarching provision, Section 142 of the 2003 Act, which makes it clear that one of the purposes of any sentence, criminal sentence, is rehabilitation.
But not here.
I understand. It's only in English. But it would be difficult to suggest that that would not be one of the objectives, one of the aspirations of penal servitude in any system, whether it appears expressly in the statutory provision or otherwise.
I think you'll find, Advocate General, that the Americans have got lots of views on that.
Well, a wholly different regime, my Lord, and it may not assist us to actually examine it in any detail. The second point I would make, my Lord, and it's one that's been touched upon already, so I don't dwell on it, is that the appellant's licence was revoked and he was returned to prison during the custodial term. And so again, at the point at which he returned, Article 5.4 would not have applied, following the majority view, in Wisdom. And following his return to prison, he was offered, as has been pointed out, a whole series of rehabilitation opportunities. And it is clear that when addressing the scope of any duty, assuming that I'm wrong in my primary submissions and the duty could apply, the ancillary duty could apply to the appellant, one has to look at his conduct throughout his period of imprisonment in order to assess whether a breach actually occurred. And so, for example, and I'm not sure it's a point that's already been mentioned, One of the appellant's complaints is that upon his transfer to Her Majesty's Prison Edinburgh in June 2011, the prison could not provide courses that had been recommended to him. But if one actually examines the chronology and the detail of the documents that have been referred to a moment ago, one finds that the appellant was referred to or transferred to Edinburgh because of his violent conduct towards other prisoners in his existing prison. Now, all of these features would have to be taken into account in determining to what extent, if at all, he was actually in breach, or there was an actual breach of the duty, assuming it was ever owed to him. We know that the custodial period of sentence expired in August 2012, and the appellant then complains that he was not provided with the appropriate courses until January 2013, a period of about 5 months. Now, even if your lordships are against me on my primary submission, the secondary submission is this, that there are simply no circumstances in which one could conclude that there had been a breach of duty in the circumstances of this case. The threshold is, after all, a very high one. As the Strasbourg Court observed in Cayenne, and I won't go to it, but it's at paragraph 70, tab 45 of the authorities, MS 1759, instances in which there would be a breach of the duty, whether one construes it as Article 51A or the ancillary duty, will be rare. And on the facts of this case, and looking at all the circumstances outlined in the agreed documents, one doesn't get anywhere near the point where, if the ancillary duty existed, one could construe it as having been breached, when, in fact, any delay in the provision of courses was partly attributable to the conduct of the appellant himself, and was, in any event, to be measured in a matter of months and not years. And I believe reference was made to the Alexander case, for example, where one was addressing delays in provision over a period of years. And indeed in James itself, which was dealing with IPP, the delays were of a wholly different magnitude. And accordingly, one couldn't, even if one concluded that there was a relevant ancillary duty owed here, view this as a circumstance in which the duty has been breached. Finally, my lords, and it's a short point on damages, it respectfully appears to us that even if there was a breach, the appropriate remedy is declaratory. There is simply no grounds for awarding damages pursuant to Section 8 of the Human Rights Act and the circumstances of this case. But if there was room for an award of damages in the particular circumstances of this case, then I would turn to the guidance, perhaps, I would term it, given by my Lord Reid in the case of Stirling, where the damages were measured, I believe, at about £50 a month, and that is how we arrived at the figure of £250. Just to explain why that figure was actually...
It's a 5-month period.
Indeed. So, my lords, unless there's any further matter upon which I can assist the court, that, in short compass, is my submission, barring one point that my learned friend wants to draw to my attention. Of the appellant to Her Majesty's Prison Edinburgh on 30th June 2011, if one looks at MS 351 and MS 440, I think one will find, I don't think it's necessary to go there at the moment, that the appellant had been involved in a fight with another prisoner, which led to his early transfer. But if I've misunderstood the position, then I will no doubt stand corrected.
This was when?
I believe it was 30th June 2011. If we go to the chronology, my lord.
Yes, I'm just looking at appellant transferred, yes.
Yes.
And then it refers to 158 and 75. I don't know whether they're in the appendix. I don't know if there's any assistance there.
He was, I see in November 2010, he was charged with assault after an incident on the 2nd of November when an inmate was assaulted in his cell. And then he was found guilty under prison rules.
Well, if there's some correction to be made, I'll leave it to my learned friend to make it, but that is our understanding of the position of the law. So unless there's any further point that I can assist the court with, I'll simply rest my submission.
Thank you very much indeed, Advocate General. Thank you. Mr. Weisselberg. Mr. Dunlop. Again, if you'd like to take your time sorting out the lectures.
Well, I wonder, my lords and my ladies, as I do so, if I can simply indicate this, that we are obviously some way ahead of schedule. I have a half-hour submission. I am perfectly content to deliver it now. I'm perfectly content if your lordships and my ladyship prefer to draw stumps now, or we could do it tomorrow morning. We're obviously going to fit within the time scale, and I'll simply follow whichever the court prefers as to when they hear from me.
I think Ms. Dunlop, that's a very helpful suggestion. When we started on Monday, we commented on the fact that this was a historic occasion. We were sitting for the first time in Edinburgh. It may be that people are going to come tomorrow morning to see us, and if we do what we might otherwise do and aim to finish today, we may disappoint some people who are hoping to see us tomorrow morning. So I think, unless I've got that wrong, and please tell me, anyone, if I have, I think on this occasion we'll probably take up your suggestion and resume tomorrow morning. But if that's inconvenient to anybody, or anyone thinks that's inappropriate, please say so.
Well, I think, the Lord, the court will need to hear from Ms. Bain in reply.
Of course, no, exactly.
And I doubt we're going to manage to fit that in, but it's frankly, the court is faced with either hearing half an hour now, half an hour tomorrow, or an hour tomorrow, and it may be convenient to just hear an hour tomorrow.
What I was trying to get at was that if this was a normal hearing, we might actually sit a bit late to finish everything. But I think the right course is, as you rightly say, we could just have another half hour tomorrow morning. But I think it would be better to have an hour tomorrow morning, and then you and Mr. Bain can both think about what you're going to say overnight. Very grateful to you. We will adjourn now then, and resume again at 10:30 tomorrow morning. Court's now adjourned.